Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. We're going to look at one of the rules of evidence in Alabama. It's Rule 408, very similar to, basically identical to the federal Rule 408. And this involves compromise and offers to compromise. And we'll look at this really in the context of a debt collection lawsuit. So a debt buyer like LVNV or Midland or Portfolio, somebody like that is suing you, and the lawyer says, hey, let's go talk. Let's talk about settling this. Now, if you say something such as, well, I'll pay you 50 cents on the dollar, 75 cents on the dollar, is that an admission that you owe the debt? And if you don't settle it, can the lawyer, the collection lawyer, bring that up? Or if you say, well, I know I owe this debt, but I don't have enough money to pay it all, can they bring that up? Well, let's look at it, because the general rule is that settlement negotiations are not allowable. In other words, you cannot bring those up in front of the judge. Okay, so let's look and see exactly what we've got here. So there's two sections: prohibited uses and permitted uses. And so we'll start with this one. And so evidence of the following is not admissible. Well, let's see exactly what it says. On behalf of any party, so a party is the plaintiff, the debt collector that sued you, and you're the defendant, the one sued. So not admissible on behalf of any party when offered to prove liability for, invalidity of, amount of a claim that was disputed as to the validity or the amount, or when offered to impeach through a prior inconsistent statement or contradiction. And so let's just look at this real quick. So you can't use a settlement offer to say, see, that proves that the consumer owes this debt because he agreed that he would offer some money for it. And the fact that the debt collector says, look, I sued you for $5,000, pay me $3,500, not the full five, that doesn't mean that it's an invalid claim. Okay. So then we have this subsection 1, which is furnishing or offering or promising to furnish, or accepting or offering or promising to accept valuable consideration, and compromising or attempting to compromise a claim. Consideration just means something that you either pay somebody or you give up a right. Okay, so oftentimes we use this terminology in a contract. We say there has to be consideration on both sides. So I give up $5,000 and you give up your car to me. Okay, so this is saying if you promise, if you agree, if you talk about compromising a claim, settling a claim, that doesn't come up. And then number 2 is conduct or statements made in compromise negotiations regarding the claim. So, you know what? Maybe I do owe this debt, but I don't have $5,000. I'll pay you $3,000. Well, that's not supposed to come up. And same thing for the collection lawyer. The collection lawyer says, look, I've sued you for $5,000, but there's some question about this. How about you pay me $3,000? Well, that's not an admission. That can't come up before the judge in trial, that the debt collector really doesn't have a right to sue you. The idea is we want settlement negotiations to be encouraged without that coming back to bite you, okay? So permitted uses. So this does not require exclusion if evidence is offered for purposes not prohibited by Section A. So remember, that's up here, the prohibited uses. So examples would be proving bias, prejudice, negating a contention of undue delay, proving an effort to obstruct criminal. So look, this is saying if there's some legitimate reason to bring this up that does not involve trying to persuade the judge or the jury that you owe this debt, you don't owe this debt, then maybe you can bring that up. But that's construed very narrowly. So let's look here at just a little bit of this. So we have this first sentence: by excluding evidence of offers to compromise or settle. This rule promotes the policy of encouraging parties to settle their disputes. And then we've got this next sentence. The theory underlying this rule is similar to that underlying Rule 407. Evidence of offers to compromise is inadmissible only when it's offered for the expressly impermissible purposes of proving liability for or invalidity of the claim or to prove its amount. And so this is the same as the federal rule. and just says such a general exclusionary rule regarding offers of compromise has long been recognized in Alabama. So here's a case from 1985, a case from 1943, and says chief among the permissible purposes for which otherwise precluded compromise evidence would be admissible is that of proving the bias or prejudice of a witness. Okay, and again, that's going way back. And so we won't really look at the rest of this. It gets kind of detailed more into, there's something called an offer of judgment. And sometimes we're suing multiple defendants and we might settle with one defendant. Well, can the jury be told how much that first defendant paid us? That's not really relevant to us when we're talking about a debt collection suit. So the bottom line with this, and obviously if you're not in Alabama, check your own rule, your own state's rules. But most states are going to have this concept probably with the exact same number, Rule 408. And it's just saying that if the collection lawyer offers to settle it for less than what he says that I owe, I can't go, Judge, out in the hallway 10 minutes ago, even though he's trying to get $5,000 from me, he said he'd take $3,500. I think that proves that I don't really owe $5,000. Well, if that was allowable, the collection lawyer would never try to settle a case. We'll flip it around. If the collection lawyer says, look, you owe $5,000, I'll take $3,500, and you say, you know what, most I can pay is $2,000. He said, no, I can't take that. And he said, isn't it true? 10 minutes ago in the hallway, you offered $2,000, which is an admission that you owe this debt. Well, then no consumer would ever talk. So the judges want us to talk. They want us to try to settle cases. They're not going to make us, but they want us to talk about this. And if either party was allowed to bring this up, then there would be no settlement discussions. And look, you can imagine, I've had cases where the settlement numbers, where we're suing somebody maybe for a wrongful death, we may be talking in the millions of dollars, okay? Well, you could never settle that case if I could come into court and say, well, that trucking company just out in the hallway offered $1.5 million. So obviously they're guilty. And same thing, they shouldn't be able to say, well, John started off at $3 million and then he came down to $2 million. So obviously, he doesn't have a good case here. We could never settle a case. There could never be mediation. I think I did a video on the difference between mediation and arbitration. Mediation is where you come together in front of a neutral person and try to settle. Well, again, if that could be revealed, then nobody can mediate. Now we have a separate rule that says mediations are confidential. Okay, but you see the thread running through the law, which is we want to encourage people to talk, to try to settle their cases without that coming back and hurting them later. And so I hope you found this helpful, and I'll continue to do this series of some specific rules of evidence that I think apply in debt collection cases. And just let me know any thoughts or comments in the comments below, and appreciate you watching. Have a good one. Bye-bye.